Court. You may be seated.
Good morning to everyone. We want to welcome you to the Tennessee Court of Appeals. This morning, the panel consists of Judge Frierson on my right, Judge Davis on my left, and myself, Judge McClarty. Madam Clerk, are there any preliminary matters this morning?
No, sir, Your Honor.
In that case, will you call the first case, please?
Yes, sir. In Re Aybree, Y.
As your parties are aware, each side have 15 minutes. The appellant is allowed to take time for rebuttal within that 15 minutes. The appellee has no time for rebuttal, but will there be more than one argument on the side of the appellee?
No, sir. This is my associate.
Okay. In that case, you'll do your full 15 minutes when you come up. Okay. Have you reserved your time already, sir?
I would like to reserve time for rebuttal.
How many?
5 minutes.
5 minutes. Okay, then you may come before us. Mhm.
Good morning. I am Michael Menifee. I represent Paige Caldwell. She is the mother of Aybree Caldwell. This appeal arises out of a Knox County Juvenile Court order terminating Ms. Caldwell's parental rights to Aybree. Aybree is now 11 years old as we stand here today. We argue that Ms. Caldwell was denied her day in court. The underlying trial proceeded in mother's absence, without proper notice to her, without an attorney to protect her interest. If the underlying order stands, this child will have lost her mother without the trial court ever balancing the actual underlying facts of the case. We've presented 4 related and intertwined issues for this court to consider. The first is whether mother received proper notice of the trial. We have argued that the juvenile court, so that as the court understands, each court in Tennessee has the right to make up its own rules about how we set trials and how we reset trials. In this case, the juvenile court for Knox County has local rules that govern how we set trials and how we reset trials. The trial in this case was set by the court, and then a week or so before the trial, it was reset by agreement of the parties. That order went down and essentially said we agree to reset the trial that was in April. And
When you say parties to both sides?
that's correct, Your Honor.
Okay, go ahead.
But didn't, in Knox County local rules, they provide that you must put a reset date in the order. The order doesn't include any kind of reset date, and then there's nothing in the record after that order goes down that shows notice to mother or her counsel.
What did the parties agree to then? Did they just agree to reset the case? They didn't agree on a date to be reset?
That's correct.
Up?
Yes, that's correct.
And this was all that was in the order?
All that was in the order was we agreed to continue the trial date that was in April, period.
Go ahead.
When the case came on for trial at the very end of July of last year, the mother's counsel was present in court. We don't know how she knew to be there. And my client was not in court. And so the court proceeded without her. Mother's counsel stood up and asked the court to continue the case, explained to the court that mother had been very involved in all the litigation. She had set for discovery depositions. She had answered written discovery. She'd done everything that she was supposed to do up until that point. However, she had lost contact with her in what she described as a few weeks before the trial.
Was there any attempt by counsel to notify his client of the trial date? Or what about the court? Did the court send out an order regarding the trial date?
So the court did not set out any kind of order regarding the trial date. And all candid, as the record reflects, mother did find that she had received an email the weekend before trial from her lawyer that said, you know, we've got trial coming up in 2 business days, and mother hadn't seen that email before she got into court. So she didn't get the 5-day notice that we would all get for, you know, any kind of motion hearing or trial. She got 2 business days before court. She did get an email.
And I think you were saying that her lawyer had indicated at the trial that she had been trying to contact your client for about a month before and just hadn't heard anything?
Yes, I believe that she told the court that there was, for about 3 weeks, she had tried to contact the mother. It wasn't clear on how many times, and that she wasn't present in court. And so she asked for a continuance. That was denied. And we allege, or we argue today, that denial was an error. Following the Terry factors, the court was to consider the length of the pendency of the proceeding, the reason for the continuance, the diligence of the party seeking the continuance, and the prejudice to the requesting party if a continuance is denied. When you look through the transcript, it appears that the court looked at one of those factors, and that was the length of the proceeding, but ignored the following, the second, third, and fourth factor. We argue all those factors favor the mother in this case.
Excuse me for interrupting, counsel. Had previous continuances been granted in this case?
The only continuance that was granted in this case was the agreed upon continuance from April to the one that was continued, that we didn't get notice of the next trial. So there was never a request for a continuance that was opposed, you know, and then granted.
Counsel, the attorney obviously had notice of the trial date, and because they sent an email to the mother, isn't the knowledge of the attorney imputed to the client, especially when the attorney has indicated, produced proof that they have attempted to contact their client?
Well, Your Honor, I think that being provided notice and then having notice is 2 different things. If the attorney learned over the weekend by a phone call or whatever it was that they had trial and then sent an email out to her client, that is not the same as being provided notice by the other side. There's nothing in the record that either the court or the petitioners in this case were provided any kind, or provided notice to mother's lawyer or to mother.
Okay. Go right ahead.
The next thing, and kind of a very important issue in this case, is whether the court erred in allowing mother's lawyer to withdraw. So after she asked for a continuance and was denied, the mother asked immediately to withdraw from the case without any kind of notice to my client. We've argued that this case is similar to this court's case in Re Lila F. In both cases, in Re Lila F, in the present case, the mother wasn't present at the outset of trial. Both lawyers said we've been having trouble reaching our clients, and they've had trouble attending appointments. In Re Lila F, the court looked to Rule of Professional Conduct 1.16 and found that the record in that case didn't support a finding that mother failed substantially to fulfill an obligation to her attorney, or that there was evidence that the representation had been rendered unreasonably difficult. Further, that mom didn't have any kind of notice that her lawyer was going to withdraw. Similarly to that case, our case, we argue, is a little stronger than that. The facts of N. Ray Lila F., mother had failed to appear at previous hearings. The mother's attorney argued that she knew that the mother knew of the trial date that day. As a matter of fact, she had spoke to her earlier that morning, and she knew about the trial date and didn't appear. Also, the court found, based on the statements of the lawyer, that mother had missed multiple appointments with her counsel in the weeks coming up to the hearing. In our case, we argue is stronger in that mother actively participated in the litigation, and there's nothing that contradicts that. Up until a few weeks, the mother's counsel stated up until a few weeks ago, mother had been very involved in this case. She did depositions. She brought me discovery answers that were asked for of opposing counsel. She had done everything that she was supposed to do until day of trial. There's no evidence or argument that mother had notice of the court date or actual notice of the court date. Mother had missed, in our case, one single appointment with her lawyer, and her lawyer emphasized she had a meritorious defense. And so that my time is up there, but we argue that our case is stronger than the case we rely on.
Thank you. You have your time for rebuttal. Yes, ma'am. Mm-hmm.
So as counsel stated, they raised a few issues. They raised the issue of whether the juvenile court erred in allowing mother's attorney to withdraw. They brought up the issue of whether the juvenile court erred in denying mother's motion for continuance and proceeding to trial. And then the third issue they brought up is whether or not substantial evidence supported the trial court's findings. I'm going to try to address my arguments in the order that counsel brought them up. First, with regard to whether the trial court erred in proceeding to trial and denying the continuance. The case on point is Cardiac Anesthesia Services versus Jones, and it says, quote, "Once it has been established that the attorney obtained the relevant knowledge during the course of representing the client, the constructive notice thereof to the client is conclusive and cannot be rebutted by showing that the attorney did not, in fact, impart the information so acquired." It is undisputed that mother's counsel had notice of this trial date. She appeared. It was set by agreement, and therefore it cannot be rebutted that mother had notice, constructive notice of the trial date. With regard to the facts of the case, I do have exactly what mother said. This is on page 7 of the transcript at the bottom. She says, I have tried to communicate with her several times this month, as recently as yesterday. I have not received a response from her, so I'm not really sure why she is not here for today's hearing. So I would ask the court for a continuance on her behalf. That's what mother actually said.
That's what mother's counsel said.
That's what mother's counsel said, yes, ma'am, thank you. So even more strong argument than that in Cardiac, we have here an attorney who testified in support of her motion for continuance that she had attempted to call mother and did not know why she did not get a response from mother. And we also have in the record that mother acknowledges receipt of an email that her counsel had sent to her prior to the trial date, and that she had just not opened it. So in this case, we, even more strongly than the Cardiac case, we have evidence in the record that mother's counsel did in fact communicate the existence of the trial date. So mother had notice. With regard to the second point, she wasn't there. The judge, I think, was within his discretion on those facts to deny the continuance and to proceed to trial. That brought up the second thing that she did. She says, you know, I need to withdraw. I haven't talked to my client. I can't be prepared. Mother's counsel specifically said that she had a meeting set to prepare for the trial with Mother, and that Mother was a no-show. And in the record, she says, based on that, I can't do anything to assist Mother today, and I'd like to withdraw. And the court allowed her to withdraw based on those facts.
What about the court allowed counsel to withdraw, but without showing any type of notice to Mother?
That's under Rule 1.165. I understand that the concern. Rule 1.165 would be an issue but for the waiver issue, which is what I'm getting ready to discuss. The courts of appeals have been clear that a litigant may waive their right to counsel that they would otherwise have. Let me get you the case that I talk about that.
The counsel did make a request of the court to withdraw.
She did.
Now, that request was made at the time counsel was representing Mother, was it not?
It was.
So that Mother, even if she did not have prior notice, definitely would not have had notice at that point.
I didn't hear that last bit.
Mother would not have had notice of that attorney withdrawal at that point, where the attorney has already represented Mother up until that point, and now the court is proceeding with the trial. The court has denied a withdrawal request without Mother knowing of that fact, but the court still, you can withdraw, and let's go ahead and we'll proceed without Mother. Nobody's here representing her interests at all.
If I understand what the court is driving us toward, I would draw the court's attention to the case of Re Aybree M, spelled Tavarius.
That case in your brief?
Mm-hmm.
Okay.
It's a 2020 case, and in that case, the court held that improper notice of intent to withdraw is no defense when a party waives their right to counsel. Okay? Our position in this case is that Mother waived her right to counsel. A parent, under the case law, waives their right to counsel when they do not participate in preparing the case for trial. So the fact in this case was that Mother's counsel specifically said, look, I had a meeting set with her to get ready for trial, and she was a no-show, and I don't know why. She never called. She never told me what was going on, and she hasn't responded to my phone calls. She hasn't responded to my emails. We would respectfully suggest that that amounts to a waiver.
Excuse me for interrupting, counsel. Did the trial court make specific findings with regard to RPC 1.16 and the waiver?
No.
Thank you.
What that issue, this specific issue, is going to boil down to, and I've talked about this and debated this with my opposing counsel, for whom I have the utmost respect, is going to be the court comparing the facts, in his case, Re Lila F, with another case that I cited in my brief, Re Elijah B. Both of them are cited in my brief. In the case of Re Lila F, Mother was not present when the trial began, but showed up midway through. The statement of counsel was she had, quote, that the mother, in that case, had difficulties reaching my office and attending appointments with me, and that she had told her lawyer that she would be running late due to a job interview but would be there, and in fact she did show up. Compare that to the facts in Re Elijah B. In that, the Court of Appeals upheld the notion that that the litigant had waived the right to counsel on these facts. This was a father. The father's lawyer did not know why father failed to appear for trial. Father's lawyer had advised father of the court date. Father had not contacted his lawyer for 2 months prior to trial, and father's lawyer had been unable to reach father for 2 months prior to trial. If you compare our facts to the facts of Lila and Elijah, we respectfully suggest they more closely resemble the facts in Elijah. And mother's attorney in this case said she didn't know why she wasn't there. She said that explicitly. Mother had advised the client of the court date. Mother's lawyer had advised mother of the court date. In our case, mother had not contacted the lawyer for approximately at least a month. I don't know if I can get us to 2 months on this record. There had been an appointment that she had failed to show up that was more than a month, but I don't know if there was communication in between that failure to show up for the appointment and notification of the trial, but I do know I have at least a month. And mother's lawyer testified that she had been unable to reach mother for at least a month. Mother never showed up at the trial. Mother did not communicate with her attorney that she was going to be late for any reason. And in Lila, the lawyer said she's had difficulty reaching me. In Elijah, the lawyer had been unable to reach mother, which was the facts in our case. So based on that, we would say that the facts support a finding that mother waived her right to counsel consistent with Elijah, and that the facts are dissimilar to the facts in Re Aybree B. I have a little bit of time, so I'm about to shift gears, unless you have questions for me on those 2 points, to the substantial evidence, which my esteemed counsel did not have time to deal with. He says there were not enough facts to support these findings. 1, that mom had failed to resolve her substance abuse and mental health issues. 2, that mother had an ability to live independently and did not apply for public housing. 3, that she was in an intimate relationship with a domestic abuser. 4, that she lacked a legal source of income, or, in the alternative, that she didn't use any of that income to support her child, thereby 5, that the visitation quality varied, and 6, that the mother never provided proof of insurance or a valid driver's license. So the grounds that the court found supported by clear and convincing evidence that mother should have her rights terminated were abandonment by failure to support. The facts that the court relied on was that she worked at Cracker Barrel, Token Games, and First Watch, but that she had not provided any financial assistance to father or provided any necessities. The court found that she paid for supervised visits and gave some gifts. Mother argues that this constitutes support under In Re Elias S, but we respectfully suggest that is not a correct ruling. Paying for visits goes to the issue of willfulness in terms of failure to support, but not to the issue of whether support was provided at all. The second ground was failure to manifest. The court found that she never complied with a prior order in the juvenile court and in the DNN case, requiring her to seek A&D treatment or submit to drug testing. That's on page 70. She drank alcohol on the weekend prior to her deposition, page 61 to 62. She was arrested for use of meth. She admitted to maintaining an intimate relationship with a person who she had used meth with as recently as a month prior to, I think it was a month prior. My notes say trial, but I think it was a DNN trial. I don't want to misstate the record here. The reference is on page 59 to 60 if you want to check me. She lived independently only briefly before being evicted and having to return home due to non-payment of rent. That's on page 52 to 53. The relevant part of this is 52 to 79 in the transcript, Your Honors. The third one was a failure to resolve the conditions. Many of the facts were the same. A court found she did not get mental health or drug and alcohol treatment that she had been ordered to get. She had a legal source of income but did not devote any of it to providing for the child and had no car or driver's license. All of these were things that DCS required of her in order to obtain a return of custody, and had in fact required of her years before, and she had not done. Under the law, of course, we only have to show one ground. By clear and convincing evidence, the court found 3. And there are specific pages in the record that cite And I would draw the court's attention specifically to pages 52 to 79, if you want to save you some reading. I have committed a miracle, and that I still have 2 minutes left. Does the court have any questions for me?
No.
If not, I will relinquish this and note that somewhere in Hades, it's real cold. Thank you.
Yes, sir, your rebuttal. No, he doesn't.
I do want to clarify a couple things, because I think it's important, because I think that when we're drawing distinctions between these two cases that come from this court, the Lila F case and then the Lila B case, when we have argued that our case mostly resembles In Re Lila F, and has stronger facts than that case. My opponent argues that the court, that this is a case where mother waived her right to counsel and relies on In Re Lila B. In Re Lila B, the court found that mother had waived her right to counsel where the client failed to assist in the preparation of the case, presumably at all, and failed to communicate with her at all in the 2 months before the trial. Our case, in contrast to that, mother's lawyer reported that she had been very involved, that she had assisted counsel in preparation of her case, all the way up until a few weeks prior to trial. And I don't know that arguing over this one or more weeks is that important, but what the record says is that mother's counsel, and I've cited this right in my brief, tells the court this case has been going on for some time. Up until a few weeks ago, mom had been very involved in this case. She did depositions, she brought me some discovery answers that were asked of opposing counsel, and then when you get to the reference to the month, she says, I've tried to communicate with her several times this month. Presumably that is over up until a few weeks ago. So I think that we're talking about a 3-week time span when mother wasn't actively participating in her case, and then up until then she was very much participating. So to say that she participated 100% up until 3 weeks ago in preparing her case for trial, including all the discovery that was talked about, and then lost contact with her lawyer for a period of a few weeks, I don't believe that you can stretch that to she's waived her right to counsel. Certainly she didn't believe that she was waiving her right to counsel. As for the facts and conclusions, I think that we have laid those out in our brief. I do believe that there are several findings of fact that couldn't be reached on the record of this case. I believe that this is a matter of we came to court with questions that we were going to ask our client. We asked those questions, we expected certain answers and drafted the order based on that, and we didn't quite get there. And so that's some of what I was trying to point out. Additionally, though, as I argued more in depth in our reply brief, the order in this case, there is nowhere in the order that says we are making these findings by a preponderance of the evidence. There's nothing in the case that says we are making our conclusions by clear and convincing evidence. Clear and convincing evidence is nowhere in the order. And so I think that that's important. I don't know that gets us a new trial, but I think it's important that the order doesn't say that.
Thank you, sir. Sorry. You don't get the time. You don't have the time. Unless my colleagues. Okay. No, I'm sorry. Well, thank you both for your presentation on your cases. Your case now has been submitted to this court for resolution. You should receive our